Hey everybody, Bill Sack here, Director of Legal Operations with the Second Amendment Foundation. One of the more recent trends in unconstitutional gun control, and a particular darling of the now lame duck administration, have been red flag laws. Over the last handful of years, we've seen a proliferation of these pernicious statutes, known particularly for turning the expectations of due process on their head. That is precisely why SAF has launched and undertaken this past year our Capture the Flag initiative, aimed at red flag laws in 6 particular jurisdictions that have enacted statutes that are particularly problematic. Cue our case Willey v. Brown, challenging Maryland's red flag statute. This week, the enigmatic attorney Edward Palcic from Bachner Law represented SAF in the Maryland Supreme Court, where the question before the court was rather straightforward. Does the, quote, reasonable grounds, unquote, standard set forth in the statute connote an evidentiary standard lower than probable cause? This question is central to our associated federal challenge, as the temporary risk protection orders that only require reasonable grounds for a judge to issue them results in the ex parte disarmament of those subject to the orders. Despite doing his best contortions, and even going so far as to blame the limitations of the English language, the attorney representing the Maryland Attorney General's office flatly conceded the point. The Maryland red flag statute does allow the issuance of certain red flag orders upon evidence less than probable cause, the standard that is typically required for warrants in other contexts. That decision now rests squarely with the Maryland Supreme Court. Once they've rendered their opinion on this insular issue, our broader case in the federal district court can resume. You can read all about Willey v. Brown at saf.org, and you can follow along here on all of our various socials for ongoing updates. I'm Bill Sack, Director of Legal Operations with the Second Amendment Foundation.